I'm from Homes England and I work for the Local Government Capacity Centre. I'm absolutely delighted to welcome you to our summer learning programme. This offers a series of knowledge sharing events on topics that you have told us are of interest to you. Today's session will be on understanding CPOs and it will be delivered by Avison Young. The Summer Learning Programme is brought to you by Homes England new Local Government Capacity Centre. So this slide summarises who we are and what we do. The Local Government Capacity Centre develops, curates and designs well-structured, accessible offers for local government with the aim of increasing capacity and skills to make homes happen in the short, medium and long term. We've launched the centre following extensive research and consultation with both local governments and a whole range of other partners to determine which areas authorities want the most support and how this can be best delivered. The Summer Learning Programme is one of our first initiatives. We are starting small, but we have a lot more to come. Now I will hand over to our wonderful speaker team. So firstly, I would like to introduce Ben Seckham and Cameron Hussain, who are from our infrastructure grants team that will be opening the session. Thank you.
Thanks very much. So welcome everybody. I'm Ben Seckham. I'm the Assistant Director of the Project Management function within the Infrastructure Grants business. So I was just going to talk briefly about who we are and what we do. So we manage a broad caseload of grant-funded capital projects across a number of different programmes. This involves contracting with typically public sector partners to fund infrastructure works which unlock housing. So our team, the project management team, manage those cases from the point of contracting through the drawdown of funding to the delivery of infrastructure and housing, right the way through to any clawback assessment and to project closure. And we sit within the Investments Directorate of Homes England. So our core objectives can be boiled down to managing the grant agreements, monitoring project delivery on behalf of MHCLG, our parent department, and actively providing support to our partners to maintain and drive forward project delivery where we can. The programmes that we manage include the Housing Infrastructure Fund, which is subdivided into forward funding, which involves larger projects up to about £250 million of grant funding, and marginal viability funding projects, which are typically at the smaller end, but up to 20 million. We also look after the Local Authority Accelerated Construction Programme, which is similar in scale to the Marginal Viability Fund, again, up to about 21 million, I think, is the largest there. So the caseload aggregate value is about 3.8 billion overall that we manage, which should unlock about over 300,000 homes. And bringing it through to more the kind of topic of today, the infrastructure that we manage is pretty broadly defined and covers a number of different types of packages, from remediation and abnormal costs through to transport, utilities, schools, green infrastructure and blue infrastructure, etc. Almost every category you can possibly imagine. So there's a great breadth and depth there. And the team is national, it's multidisciplinary. It has a number of different professionals in there, from planners, surveyors, accountants, engineers, etc., with a common denominator of public sector capital project experience. But the real thing that links through to today that I'll hand over to Cam in 2 ticks to talk about is a lot of our projects involve land acquisition and assembly. So that's pretty pertinent to today, and also often involves CPO. So at that point, I will hand over to my colleague Cam.
Thank you very much, Ben. Good afternoon, everyone. My name's Cameron Hussain, and I'm a senior PM, a project manager in Ben's team. And I act as the day-to-day contact for the local authorities receiving infrastructure grant funding. And I'm just going to talk very briefly on why and how we came to seek CPO guidance. The first element is to talk about is probably the external drivers. And by external drivers, I mean external to the infrastructure grants project management team. So my contacts in the authorities, LAs, are bound by a funding agreement, and that sets out milestones and conditions relating to infrastructure delivery. And as Ben mentioned, a key and increasingly common component of that infrastructure is land assembly. There was a specific instance where an LA colleague was contemplating CPO, and they had limited experience and knowledge, and they asked me for help. And they wanted to understand more about the process, how to incorporate costs and time, and frankly, to understand the complexity and therefore the importance of getting professional advice at the right time. Internally, as Ben mentioned, we're a mixed disciplinary team, and though we come from a variety of professional backgrounds, and some of us are planners, we're not all planners, and this is a really complex topic. So we wanted guidance that would cater to us as a team, as well as something we could potentially offer to local authority colleagues who were interested and needed to know how that would work alongside their funding agreement and the programme management. So the last element probably to touch on as well for our benefit internally for Homes England was to be able to consistently support our local authority colleagues when it came to them asking to incorporate CPO, because that would have an understandable impact on time and costs and deliverables. So how did we go about doing it? Well, first of all, we checked with internal colleagues to see if there was something like this already available, something we could either update or just share. We didn't find anything. So we worked with our local authority colleagues and internal colleagues to gather requirements. We took advice from our director about how to go about procuring services, and that's how we came into contact with Virginia and Avison Young. We worked together, developed a skeleton of the elements we'd like to cover, and specifically focusing on LAs carrying out CPOs. And since our programs fund LAs who are increasingly relying on this process, it was very topical. There were a number of iterations, lots of comments. We tried to manage the language as well as trying to keep it at a level that was useful and catering to differing levels of understanding of CPO. Once it was finalised, we worked with our Centre of Excellence colleagues and MPP colleagues to make sure it was fit for purpose, did what we needed it to do as much as we could. And there's an acknowledgement that it will probably evolve as legislation changes and as the needs of those people using it changes. Our aim was initially that this guidance document was primarily for internal purposes, but it should be suitable to support LA colleagues in a collaborative manner to help us act as a critical friend or inform a discussion should that become needed. I'd like to end by saying that we were really pleased to have Virginia and team present today and share the work that we developed together. Thank you.
Thank you, Cameron, and thank you for that very kind introduction and summary. As you say, it was interesting to get the feedback on the subjects that people were interested in hearing about, and to make sure that the language that we used in the guidance was not just our phrases that everyone who works in CPO understands, but to make sure that this is something that's going to be really useful for everybody. So thank you for that. And just before I start, I think it would be great if I could just introduce my colleagues and myself to everybody. My name is Virginia Blackman, as Cameron has said, and I lead the Site Assembly and Compulsory Purchase team at Avison Young, full-time compulsory purchase, which I think is a fascinating job to do, and I understand not everyone else would think that. But that's the team we have. With me today, I have Alison Squires, who is a director in the team and is a dual qualified planner and surveyor, so has a really useful cross-cutting view of our work and the links into that. And then Jack O'Neill, who is a surveyor in the team as well. Thank you. Next slide. So site assembly and compulsory purchase. If we could just move on, thank you. The next slide. It's a huge subject, site assembly and compulsory purchase, and as my sort of full-time job, I think I could probably spend at least a week, as could my colleagues, talking about this, but happily, there's an hour and a half at most, which is now cutting down to probably nearer an hour and a quarter, so don't panic, we're not going to be much longer than that. But we know usefully from the Slido and from our experience working with local authorities that there's a really wide range of experience. We have worked with local authorities who have made successfully and used compulsory purchase in a number of projects and have really good experience and resources in-house on that. And we have worked with local authorities who are definitely at the beginning of that journey. And so what we've aimed to do today is to give a headline overview, which will give a really good baseline for the people who have less understanding of the subject area, but hopefully will, with the addition of some of our examples and case studies and experience, provide enough of interest to those of you who have already got significant experience in this area. And I think there, from the slide at the beginning, there was a number of people who have got significant experience already. So as Katie said, there's going to be time for Q&A at the end. So we really welcome the questions if you send them through as we go along, but I think it's likely we will answer them all at the end just to keep the thing moving. And the areas we're going to cover really are who has site assembly and compulsory purchase powers, and of course that will depend on what powers we're talking about, what justification is required for those powers, programme, i.e. how long will this take? And I think that's one of the most commonly asked questions that we have when we get involved in a project. We're going to have a look at a case study to take you through the CPO process. Just we thought it might be bring a bit more colour and life to it than simply running through the legal process. We're going to give a very broad outline on compensation. Again, for those of you who work in this area, compensation could obviously be a week or two's discussion. What additional assistance over and above statutory compensation might be available to affected parties? What guidance is there out there apart from the work that we've been doing with the infrastructure grants team? And then questions at the end. So thank you. Let's leap right in with the next slide. Thank you. What I wanted to start with actually is just a little background on the site assembly, which is the team is labelled site assembly, and the presentation very much labelled site assembly on purpose. Compulsory purchase is a very important part of site assembly, but site assembly overall is the job that we are aiming to do, although our focus today will be on compulsory purchase. So if we move along to the next slide, what is site assembly? And really, we see site assembly as an absolutely key delivery work stream. And as Cameron was saying in his introduction, there are a number of projects where if the site is not assembled, if the land and rights are not available, the very real benefits of the Homes England and local authority team working together will not happen. So we see our job as assembling the site on time, on budget, free of legal risk, and that is all the land and rights that might be acquired. And traditionally, and the picture on the screen is a good description of this. Traditionally, the schemes that we worked on were for an area of land where we would demolish everything on site, potentially retaining maybe some historical buildings of interest, but pretty much demolishing everything on site and rebuilding from the beginning. But what we're starting to see, and I'm sure some of you are seeing this in your areas, is that particularly in relation to town centre projects, high streets, improvement and reaction to the changes of the pandemic, we're starting to see rights and control over property being just as important as being able to get on site and demolish everything that's there at the moment. Please, could we have the next slide? Thank you. So just as a starting point, it's sensible to look at, and as I say, our focus is compulsory purchase in this presentation today, but it's useful to look at all the tools that are available to the team delivering a project in terms of site assembly. And the starting point is negotiation in all of these instances. And we'll come on to a little bit of further information and guidance on how we see good practice in negotiations later on in the presentation with Avison. There will be a number of instances where commercial landlords have landlord and tenant powers available in respect of lease breaks, licenses which can be brought to an end in terms of refusal to renew existing tenancies because of the prospect of redevelopment. All of those kind of good, solid, standard landlord and tenant powers can be a really important part of your site assembly process and should be into the programme and a key part of that. As many of you will know, under the Housing Act, there are powers there for council residential tenants, particularly useful, of course, on estate regeneration projects in terms of providing suitable alternative accommodation for residents in order to either demolish or to improve the existing buildings. Local planning authorities have the ability to appropriate land to deal with third-party rights, and we're seeing, particularly in these sort of town centre or urban area, slotting a scheme into the middle of an urban area, dealing with rights such as rights of light or access over land, key part of being able to get on and get the site delivered. And then finally, compulsory purchase in terms of those sort of tools that are available to deliver the site assembly. And in the site assembly strategy, we would expect to see including all of those matters in terms of that. Thank you. Next slide. So just an example, a couple of examples of where site assembly has gone wrong, just to emphasise, if I haven't made it clear already, how important we think having a plan for site assembly is to ensure that the scheme is not delayed or sort of put off. The first of those slides, top left-hand corner, is a traveller site where planning enforcement required sort of possession of the site in order to deal with both the occupation and the uses to which that site has been put. The top right-hand corner, I'm told, and I haven't investigated further because it's a great story, that this is in China, where the owner of that building refused to move, and therefore the new highway was built around it until they could be persuaded to move. Now, my understanding is that that would be unlikely to happen, but as I say, let's not get in the way of a good story. And the final photograph on the bottom is one of our projects, which actually will be our case study here, but a state regeneration project in North London, where when we got involved in that, it was a very long history and background to the scheme, which had led to a difficult relationship with the residents and community, and quite a lot of protest and disgruntlement at the scheme and the prospect of having to move house to allow delivery of that scheme. So these are some of the examples of where it might go wrong if we don't think ahead and make sure that we get site assembly strategy. And I'm sure some of you who've worked on these things before will have similar examples where you've managed to avoid. Let me now pass on to Alison, who is going to talk about who has site assembly powers. Thank you, Alison.
Thank you, Virginia. Good afternoon, all. So I'm just going to briefly touch first on, crucially, what are site assembly powers for, what can you use them for, and who has them? Next slide, please. So firstly, what are they for? As a starting point, we have to always remember that the purpose of these site assembly powers is to deliver public benefit. And there's a range of different purposes for which we can use compulsory purchase powers. Firstly, is delivery of planning policy. So, for example, if you have an area action plan allocating a site for, let's say, town centre redevelopment, you can use certain powers to deliver that, or to deliver much favoured one, to deliver new homes, deliver planning policy. Then moving on, we also have powers to deliver regeneration and housing projects. So that's estate regeneration schemes, regeneration of town centres, and again, housing development. So there's a lot of overlap between the delivery of planning policy and the delivery of regeneration and housing. Powers are also there to deliver community infrastructure, such as some, really significant public benefit, such as new schools, new health facilities. And then, as many of you may have seen, and what many people have used CPO powers for, are for nationally significant infrastructure projects, such as large road schemes and airport schemes, and also kind of guided transport and navigation schemes, such as railways. Next slide, please. And who has those powers? So there's a number of always public bodies that has these powers. And these include local authorities, both in their role as local planning authority and also their role as housing authority. Homes England also has compulsory purchase powers. County councils and certain government departments have compulsory purchase powers. And then also Highways England, airport operators, and a number of utilities providers, all to help them fulfil their statutory duty. And then also Network Rail and in London, Transport for London also have their compulsory purchase powers. And all links up again to the previous slide where we talk about what are they using those powers for and what are they seeking to deliver. Next slide, please. And so key for all practitioners or local authorities or public bodies when using compulsory purchase is to, as a starting point, make sure you're using the right legislation. And there are a number of things within each separate legislation which are specific to that legislation and to the purpose for which you're CPOing. But there's also a number of factors which are mutual for every bit of legislation, which we always need to make sure that we can justify and demonstrate if we're looking to use compulsory purchase powers. And as a starter on, and we'll come back onto this a number of times throughout this presentation, and really key is about negotiations. Ultimately, we are taking land away from, which is privately held, from third parties. And so really key in the process and for all the legislation, the purpose for which we CPO is to begin negotiations in advance of looking to use compulsory purchase powers and to actually carry out those negotiations throughout the entire CPO process. And one of the key tests here is about having reasonable efforts to have negotiated by agreement. And obviously it's a very grey area, quite what is meant by reasonable efforts, but there is significant kind of case law and guidance on this, which we'll come on to shortly in some MHCLG guidance. And it's all about being able to demonstrate that the acquiring authority has actually seriously tried to acquire that land by private treaty. And this often includes making really reasonable financial offers. So whilst you don't have to make financial offers, it's often best practice to have made a financial offer based on your understanding of that interest. And as I say, this carries out throughout the whole process. The next key point is about having a clear idea of how the acquiring authority, and I should have said all the public bodies are often termed acquiring authorities, simply that they have those powers to acquire land compulsorily. And so you must have a clear idea of how you intend to use the land. And normally that involves having planning permission in place for the scheme so that you can demonstrate, look, we definitely know what we want to use this land for. But some cases, due to time constraint or cost constraints, planning permission might not yet be enforced. But it's always important to at least have a scheme there so you know what you are intending to deliver. So, for example, an outline planning consent or a very worked up road scheme, regeneration scheme. And then the next key test is about having all the necessary resources available and being able to demonstrate that these are in place or that they will be in place by the time that the acquiring authority needs to obtain vacant possession. And this is increasingly becoming a really big test under compulsory purchase, in terms of actually being able to show not only financial, but also other resources in place, such as having a team in place to deliver that scheme. If it's a council compulsory acquiring, who is actually going to be building that scheme, having a contractor, having a developer on board. And often you'll see many local authorities, for example, actually work in delivering their schemes with a developer, so they can rely on the developer's financial ability and their track record to show that they actually can develop these schemes. But obviously, increasingly, many local authorities setting up their own regens companies, also having their in-house expertise and experience to do that themselves. And then finally, the key test is really about having no impediments, is what the guidance refers it to, and being ready to proceed. And ultimately, this should be by the time you are getting vacant possession, there should be nothing else that's holding up delivery of the scheme apart from getting vacant possession of that site. And as you can imagine, it's a bit of a balancing exercise here as to how much time and money you spend on getting all those consents in place before you have your compulsory purchase in place. Next slide, please. And so just a very quick run through, I won't dwell on the legislation, but a very quick run through of some of the key legislation that we often use in terms of compulsory purchasing. And the one that I certainly myself use most is the Town and Country Planning Act 1990. And this is really about delivering planning policy and delivering improvements, what they call the wellbeing test, so being able to demonstrate that there's improvements from that scheme to economic, social or environmental wellbeing. So this may be, for example, providing new jobs as part of the construction of the scheme, improvements to the environment, such as green planting, improvements on a housing estate, and also social improvements, such as potentially more affordable housing, other public realm benefits. Quite similarly, but in a little bit less detail, is the Housing Act 1985. And this is a test here, legislation here that is used about improving the number or the quality of new homes. And increasingly this is used on housing regeneration schemes, where there's a clear case to be made that, XX number of homes have been knocked down and XX number of new homes are being delivered. And then we also have the Housing Regeneration Act 2008, which is actually the legislation under which Homes England can compulsory purchase. And the key test here and the key purpose for using this legislation is about supply and quality of housing, regeneration or development of land. And you'll see between those first three bits of legislation I've mentioned, there's often a bit of overlap between the three, and there's often a piece of work done very early on as to which is the most appropriate of those acts to use in terms of compulsory purchase. And then more clear cut, particularly for new roads, new highways, is the Highways Act 1980, which is all about where we're wanting to build new roads. And again, that has its own set legislation and requirements. Next slide, please. And then just a quick few examples from the schemes that we have worked on over the last few years, where we've used a range of compulsory purchase powers. West Hendon Estate, which is a large housing regeneration and little bits of business estate up in Barnet in London, which Virginia will use as our case study. And here we use both the Town and Country Planning Act 1990 powers, but also the Highways Act 1980 powers in terms of providing a stopping up order for some roadworks. Vicarage Field CPO, the second photo that you can see, this is a scheme over in London Borough of Barking, where we have made the CPO last week, in fact, under the Town and Country Planning Act, to deliver whole-scale change and large-scale redevelopment of a shopping centre and a wider area. And then just two examples here of estate regeneration schemes, both in South London, the Alton Estate and Winstanley York Road, both using Town and Country Planning Act powers. Next slide, please. And I'm just going to move on, and the next slide, please, to talk about programme. So one of the key questions that we frequently get asked is how long does it take to CPO? And there's often really different answers to this. Some people I talk to think you can do it within 6 months. Other people have a bad experience of it and it's taken 15 to 20 years. In our experience, it normally takes between 18 to 24 months. And you can just see on this slide here, just as a broad guide, we would normally assume that you're spending 4 to 6 months to carry out perpetuatory work, which we can cover in a moment. We allow a month to actually legally make the CPO, which is when we actually serve notices on all those people that are affected by the CPO, and they get a chance to put in an objection, or in some cases a support. Then we have a public inquiry if there are a number of objections to the CPO that can't be resolved. Again, we'd normally allow 6 to 12 months for this. Virginia will touch on this in her presentation, but either an planning inspector or the Secretary of State will then confirm that CPO. The council or requiring authority has to then serve various notices to confirm that they've done that. Again, that takes between the 3 to 12 months, further month for notification. And then there's a 3-month minimum window, and it can be more than this, from where you can actually implement that CPO and actually take possession of the site. And then depending quite on the notices served, you then have between 3 to 6 years to actually take possession. So it can be a long process, but if it's not done within those timetails after implementation, you effectively lose those powers that you've gone through all that effort to acquire. Next slide, please. And I'm just going to go into just a little bit more detail here in kind of how the site assembly, that timetable I've just run through, how it often fits in within a project. And at the very starting point where I said 4 to 6 months for your kind of early preparation, this can actually be a bit longer. Often we get involved in a CPO 3 or 4 years before on a large scheme, where there's actually a huge amount of work that needs to be done, and often actually looking at site assembly really early on can be beneficial. And so you can see on the left-hand side here, some of the key bits of work we would normally feed into a really early project delivery plan are about having a site assembly strategy, which is where we'd often look at trying to identify who the various owners, occupiers, leaseholders are. We would look at the programme, we would look at the types of land that we're needing to compulsory purchase, and making sure that we've got everything in track at the right timescale. And as part of this, often a local authority or a housing association or whoever may look at also getting into some form of agreement with actually someone to deliver this scheme. So be that a housing association or a developer, how is that scheme actually going to be delivered? And then linked to that as well, remember these are public bodies that are delivering the compulsory purchase and they have the compulsory purchase powers, is making sure that there's the appropriate policy and decision making in process. So for example, timescaling in seeking cabinet approval, council approval, various internal council, etc., public sector board approval. And then really the key point there is all about making sure we've then got a budget, so we're aware of the acquisition costs, but also being aware of the programme costs for that CPO. And then that then feeds into the green box that you can see where we talk about land referencing and CPO preparation, which Virginia will cover in our case study. And the long time and that kind of in the project as well is looking at any other consents that are needed. If you remember, I mentioned that we must show that there are no impediments to delivery of the scheme. So looking at, for example, whether any stopping up orders are needed, whether any highways works needed, and what is the timescale for getting those consents in place. And most crucially, getting that planning permission in place. This then leads us on to actually making the CPO, which I've just mentioned in terms of serving formal notices. And here, which Jack will cover on briefly in a moment, is also looking at, is there anything further we can do for those people that are affected, such as a resident or business offer? Is there anything we can offer more than just the compensation and the financial support that actually means that we reduce the objections to the CPO and we can get on site earlier? We then lead on to the public inquiry of objections, and then we lead on to the notices. And finally, you'll see in the very last box, we talk about compensation. And it's just important just to quickly note that all we've talked about so far is all the process of CPO in terms of how you get that CPO confirmed that you can use the powers. And actually alongside that, there's also a process of actually looking at the actual compensation. Next slide, please. And so you probably gathered from what I've said so far, a key bit of the site assembly process is all about preparation. And preparation really helps us to make sure we actually have a confirmed CPO, we can get everything in place, coming back to Virginia's points at the beginning, on time and on budget. Next slide, please. So just one final slide from me before I hand over to Virginia is just to dwell just briefly on the importance of negotiations and early engagement. And if you remember, we put this in at the very early stages of the CPO process, and this often begins way before any acquiring authority actually starts the actual formal CPO process. And one of the first stages is making sure that we have identified all the third parties, be this freeholders, leaseholders, tenants, occupiers, anyone who might have a right over the land that we are looking to compulsory purchase, and actually seeing what their property interest is. So we've got a clear understanding of what it is that we're acquiring. And then really starting those negotiations early so that we can start understanding some of those key requirements from people. So for example, in our Vicarage Field scheme, we're acquiring some businesses there. So what is it that those businesses need? Do they actually want their business to be shut and just want compensation, or do they want to be relocated elsewhere? And is that possible? So it's actually looking at those key requirements. And then linked to this really is about trust building. The MHCLG guidance we come on to later on is very clear on this, that from the start is often a good idea to have a dedicated officer at the council or from the consultancy leading on this, and actually have somebody that anyone who's affected by a CPO can actually come and talk to that person. And it's all about making sure that we are, as practitioners, feeding back to those people that are potentially losing homes, businesses, rights. And just finally, those negotiations carry on throughout the entire CPO process. So it's not a case of the CPO is made and these now end. They should continue throughout. And in our experience, often, in fact, at a CPO inquiry, we suddenly get a massive flurry of people wanting to negotiate. Perhaps they're worried about being cross-examined by a barrister, which is understandable, but they are actually wanting to come and talk to us at that point and actually have some negotiation and reach a deal. And I'm going to hand over back to Virginia now, who's just going to talk you through a case study on West Hendon, picking up some of the points that Virginia and I have covered so far.
Thank you, Alison. As I say, we just thought it might be helpful to actually talk about a real life example and how this project dealt with some of the issues that Alison's raised. So I'm going to talk about the West Hendon Estate Regeneration, which is the one that you saw where they had a protest banner up in my first slide about when site assembly goes wrong. It's an existing, it's approximately 600 unit social housing estate in North London, just near the Brent Cross, just north of Brent Cross Shopping Centre, is the way that we normally describe it to people. It was going to be redeveloped for about 2,000 new housing units, a new primary school, a district centre, and importantly links through to the train station at Hendon, which is going to benefit, well, is already benefiting from the Thames Link, but when we started this project was not yet the Thames Link train service, which provides a very much faster and more frequent train service into the centre of town, improving those transport links into the area significantly. So that is, I think, ticking off there, very clear indication. The council knew what it wanted to achieve on this site. It was identified within the wider Brent Cross regeneration area in the local plan. Again, a good tick in the box there. There was clear planning policy, adopted planning policy behind this project. The council had gone out and selected a joint venture between Barratt and Metropolitan Thames Valley Housing as a delivery partner. So taking, as we talk about, all the benefits of Barratt's experience of delivering new housing, all of the experience that Metropolitan Thames Valley have of managing a wide variety of sort of social and affordable housing, of resident engagement, all of those skills putting together, which they were bringing to the project there. The good news from this was that they were able to deliver phase 1 and 2 of the project on council land, and it was only phases 3 to 6 of the project which needed site assembly. So they were able to get on straight away and start to demonstrate some of the benefits of the project to local residents, which was helpful to us as we went through. There were about 140 leaseholders on the site. There were 12 commercial units, and there were, as you can imagine, a large number of council, secure and other tenants on the site. So thank you. If we move on, the preparation phase, as you see, there was a large number of those ticked off. First part of our sort of formal preparation for the CPO is identifying all the people who have an interest in the site. And then you often hear this called land referencing or requisitioning for information. As you will be aware, you've got a power to require people to push to provide information in advance of using these sorts of powers. So you can see from the plan I've got in front, this is the plan we gave to the specialist land referencers. The area edged in red is the area that we think we need to acquire to deliver. That's the area that we need to go in, demolish, or carry out significant works to buildings and rebuild on those sites. And the green area around it is an area where we think we might be impacting on those buildings or occupiers. So it might be, if you can see at the bottom left-hand corner, because we are taking a building which has a party wall with the building which will be retained. It might be, as you can see in the top left-hand corner, where you can see the sort of curved area, that's a crane oversailing, and around that as well, some rights of light potential impact. And then the area on the sort of top right-hand side is, again, where there's a party wall with the building that's being retained. So those are the areas we asked the land referencer to investigate, and you would probably identify to people that they are within a research area rather than being particular about this is a demolition or planned redevelopment area. Thank you. The next slide. And following that work of identifying all of the people who are affected, all the property and rights that are affected, the first formal document that you see in front of you is the CPO map. And those who've been involved in this type of thing before will have seen something like this, of course, previously, but useful for those that haven't. You will see that all of the area in pink is the area that we will need to acquire permanently, and the areas in blue are where new rights are to be acquired in terms of that. So you will see that having carried out all of that wider research area, we only actually need to impact on a smaller area of that, and we don't need to be notifying and including all the people in that research area. And you will see the other thing that's useful to see, I don't know if you can see in the size of this, but each of those plots has a number which will link through to the CPO schedule, which helps people, everyone identify which land we're talking about as we go through. And if we move on then to the order itself, this is, I guess, the least impressive bit of the formal documentation. The order itself identifies the acquiring authority, so in this case, London Borough of Barnet. It has the name of the CPO, which should be sort of a very obvious description of what you are doing. The date of the CPO, so this is a 2014. As you might imagine, we're using an older example so that all of the controversial issues are already resolved and dealt with. And which legislation is being used to, which legislation is being relied on here. And you see this is a Town and Country Planning Act CPO, and then the description there of what the order will allow the authority to do. So the acquisition of the land coloured pink and the new rights to be compulsorily acquired on the land shown blue, and to deliver the scheme as set out there, which is the new demolition of the existing building, the construction of the residential units, new primary school and community facility. So on the face of it, being very clear what it is you are trying to deliver and what it is you are going to do to deliver that. So moving onwards to the CPO schedule, and that's where the numbered up plots on the map that we saw 2 slides ago are useful because they link to this table in the schedule, which identifies a description of the lands that you're going to acquire. So this is 498 square metres of residential block of flats at the address 11 to 34 Marriott Close. It identifies the owner of that property, which, as you might expect in the State Regeneration Project, the Mayor and the London Borough of Barnet. And then it identifies, it splits out lessees and tenants. So leases more than 7 years and tenants with less than 7 years, and then the occupiers. And as you might imagine, the leaseholders, tenants and occupiers might well all be very similar or the same people, but they're split out like that and identified in the schedule. And those are all the people that will be informed about the CPO. So following on from that and moving on to the the making of the CPO schedule together, you will have, with these documents, you will have a statement of reasons, which is a non-statutory, but is, I think in every instance I have been involved in, is a document which sets out how and why the CPO is being made, and all of those issues that we've talked about, the negotiations which have taken place, what the scheme will deliver, the policy in place to support that, the decision making, all of those things in there. So once the CPO is made, and again, usually sealed, but you may have different arrangements in your authority, all of the people in that schedule will be entitled to a copy of that and formal notices being posted to them. You will put up a notice on site in the way that we would with planning notices, so that they can be easily identified by passers-by and local residents, and then it will be also advertised in the local paper, even though my picture is of course national newspapers there. And this is the time period where, if we move on, the people affected will have an opportunity to make their objections, if they have any, to the order. And I would say that although we do have a few instances where there were no objections or minimal, where you are affecting people's homes and businesses, it is not unexpected that you would have objections. People are likely to have concerns and want to make sure they remain involved in the process. So once there are objections received to an order, then the Secretary of State will require a public inquiry into the process. So if we move on, I've just got a little bit more information on what the public inquiry will be for those who have not been involved in this. Similar in some ways to a planning inquiry or a sort of informal sort of court-like process, whereby an independent inspector will be in charge of the process and will be the person who, in a similar way to, I suppose, a judge, will be the decision maker or the sort of reporter of information. You'll see on the bottom left-hand photograph the inspector in this situation, and there was a model of the scheme brought to the inquiry to allow for better explanation of what was planned and how that would work in terms of the scheme. There is the acquiring authority is usually represented by specialist planning barristers, and you'll see those in the top right-hand corner of the screen, who lead the case on behalf of the acquiring authority, and they will bring forward witnesses. And the witness you'll see in the bottom right-hand corner is actually the head of housing for the authority, explaining why there was a need for this housing to be demolished and rebuilt, and to improve the quality and quantity of housing and the other benefits that would bring. And then the top left-hand corner, objectors to the order will have an opportunity to put forward their case. If they want to say anything further over and above their written objections, then this is their opportunity to do so, and also to question the witnesses that are put forward by that. And some objectors will be professionally represented, and in other situations, and this is one, there may be a residents group or a business group in the area that provides general support to the people. So the council will have the opportunity to present their case using evidence. Those people will be questioned by the objectors. The objectors have their opportunity to present their case and be questioned similarly by the acquiring authority, and then the inspector will listen to all of this and also have the opportunity to ask their own questions as part of that process. Now, I'm just going to, if we move on to the next slide, in this particular inquiry, we had a large number of residents who requested that we hold an evening session of the inquiry to enable as many people as possible to be able to attend and make their case. And of course, that was something that we made available. At the time of that evening session, we also had a protest march that came from the estate to the inquiry location. We've made provision for, I think, about 200 extra people to be accommodated. I'm not sure how we do it now in a COVID secure way, but we managed to do it at that time. But unfortunately, the people decided they did not want to come in and make their case in the inquiry. They did it outside, and that's what they chose to do. So, we had there was a large number of people, so the police were there simply to keep everything safe and moving. Public inquiries do need to remain open, even if people choose to protest in a way that's not in the standard way. So at the end of the inquiry, the inspector is likely to undertake a site visit for themselves. It's not normally an opportunity to present further evidence. It's simply so that they can understand the characteristics of the site. And then what happens then? And if we move on to the next slide, I think historically there have been moments when we have thought at that stage, the closure of the inquiry, that everything goes into a black hole. But I think, to be absolutely fair to the inspector who is running the inquiry and pins behind them, there's a huge amount of work that goes on there, where the inspector has the job of gathering up all of the evidence, questions and responses that was given in the inquiry, recording that into their report, and then coming to their conclusion. And if we move on to the next slide, the two options that we now have available, following some recent legislation, historically, all decisions, the inspector would make a recommendation to the Secretary of State, and that Secretary of State would be dependent on which powers we use. So Secretary of State for Transport for highway schemes, for example, or MHDLG for a sort of regeneration or housing scheme would be the examples. Recent legislation allowed for an inspector-led decision in most cases, except where there is a national issue of national importance raised. So I think since the legislation came into force, all of the orders with which we've been involved under Town and Country Planning Act and the Housing Act have been inspector-led decisions rather than a Secretary of State decision. And the even better news on that is that the inspectorate has a KPI of all decisions within 12 weeks. And every order that we have been involved in over that timetable, they have met that deadline, which is fantastic news, because certainly that was longer when the process was twofold, going through the planning inspector report and then along to the Secretary of State. So that's been great news, certainly in terms of programme certainty and being able to get on and deliver these projects. So that's great news. If we move on to the confirmation, there's a process, as you might imagine, that you have to go through. The letter from the Secretary of State or the Inspector to the Inquiring Authority is giving the decision, that gives the reasoning and a copy of the Inspector's report where appropriate. Touch wood, assuming that the order is confirmed, that commences the next stage in a timescale for the next stage of work, subject, of course, to the usual legal challenge. And if we move on then, the notification process, with notification having to happen within 6 weeks of the confirmation of the order, very similar to the making process. Those affected are entitled to notice of this happening to be posted, site notices in usual and there, and newspaper notices in a number of instances as well. So hopefully that's added a little bit more colour and sort of context to that CPO process. And I think there have been questions coming through as we've been going through in terms of compensation. And as luck would have it, I'm going to pass over to Jack O'Neill, my colleague, who's going to take you through the compensation and additional assistance available to those affected.
Yeah, thanks very much, Virginia, and good afternoon, everyone. So I'm going to give a quick overview of compensation available to claimants affected by CPO and other types of assistance available, which can help mitigate its impact. Next slide, please. So compensation is essentially what makes the CPO process as fair as possible. The underlying principle of compensation is equivalence, which means in CPO terms that the person is put back into the position they'd be in had it not been for the CPO. Now, in reality, this isn't always the case, but I'll come back to that slightly later. So onto compensation itself, there are 5 heads of claim which a claimant is entitled to under a CPO, which is shown here. The first being market value of property, which is typically the largest payment. This is calculated based on what we call a no scheme world valuation, meaning that it doesn't take into account any possible uplift or reduction in value caused by the property by the new scheme. This can go both ways. For instance, in estate regeneration schemes, we would expect the values of existing homes within later phases to go up due to improvements to the area brought about by the earlier phases of the scheme. Whereas a home affected by a new highway, for instance, would typically see its value fall as a result of the prospect of the scheme. So it's important to take out this change out of the equation. Next, we have severance and injurious affection. Essentially, if as a result of the loss of land acquired or the construction or use of the new scheme, the claimant's retained land is made less valuable, then this compensation is payable. For instance, if a claimant had a house with a garage and the garage was purchased via CPO, then the claimant would be entitled to the amount by which the value of the house falls. So next, disturbance, which is basically compensation for any other matter not directly based on the value of the land. So this is literally covering costs accrued during the moving process. And there's no definitive list of items of claim for disturbance. Each case is considered on its own merits. But depending on the nature of the premises acquired, typical disturbance items can include removal costs, notification of change of address, legal costs, stamp duty, temporary loss of profits, etc. Also importantly to note that investor owners' reinvestment costs are also covered by this, including stamp duty if necessary. So there's a further statutory loss payment which isn't linked to any costs actually accrued. And the first one is home loss payments, which is for homeowners and occupiers. And the amount payable for a freeholder or leaseholder subject to certain conditions is 10% of the market value of the home, up to a maximum of £65,000. The other statutory loss payment is basic loss, which applies to non-residential leasehold or freehold interests. And there are two payments, one to owners and one to occupiers, at 7.5% and 2.5% of market value respectively, or an amount based on land or building area if there's no market value. And lastly, as part of the overall compensation payable, claimants reasonably incurred professional fees and costs of generally putting together the claim are recoverable. So just going back to the principle of equivalence, in some instances, compensation goes above and beyond what a claimant actually might be willing to accept. So statutory payments can actually be a sweetener, especially for investor owners where there's no emotional attachment to the property, where, for instance, they're getting 7.5% over market value and reinvestment costs paid for a future property. Next slide, please. So the basic requirements of compensation are met by these statutory payments, but the overall picture has evolved over time by way of best practice, and these guides aim to minimise the impact of CPO on residents and businesses. So Alison will go into these in more detail in just a bit, but just to introduce them briefly. Firstly, the DCLG Estate Regeneration Framework, which is a three-part guide, and it's really about promoting a collaborative approach to CPO in terms of encouraging the promoter to gain resident support through consultation and community participation in the planning process. And secondly, we have the MHCLG guidance, which is a very well written and comprehensive guide to preparing for and making a CPO, and includes procedural and practical guidance for anyone involved in the process. Now, the most common forms of non-statutory assistance are resident charters and rehousing offers, which are both really well established. These aim to mitigate the impact of estate regeneration programs on existing residents in the form of commitments and guarantees to homeowners and tenants, like, for instance, the ability to remain on site, assistance with moving, and access to independent advisors, and so on. Business charters, on the other hand, are a more evolving concept, one that we really advise clients to consider. These usually begin with an employment study to scope the requirements of existing businesses, and then the charter itself can make commitments and guarantees, such as the minimisation of disruption to trade, relocation into the new scheme, and provision of relocation support for businesses. And lastly, a practical point, which is the importance of flexibility in acquisitions. Examples of flexibility might be sale and leaseback for businesses, which will give them time to relocate, and give income to the developer, or defer completion for residential units, also to give them time to find another home. So this can also be in terms of having a collaborative approach to negotiation with residents and businesses, and also flexibility with compensation provided in order to essentially get deals done. And this is our ultimate aim, to acquire by agreement, not by CPO. And you need to be able to have shown reasonable efforts to negotiate by agreement to be able to justify a CPO if it is ultimately needed. Thank you. Next slide, please.
Thank you, Jack. Okay, just to pick up on a few points finally before we take questions that Jack mentioned. So obviously Jack set out about the compensation code and some of those wider kind of softer elements as kind of additional assistance. And just kind of really to signpost you so you can see where you can find these. And as Jack mentioned, one of the key documents that we use a lot is the MHCLG guidance on CPO. Some of you like me who's been practicing for a while, this was previously a circular back in 2004. And this really to some extent is our Bible. It sets out a huge amount of information, really clearly written on each of the bits, each of the key legislation that you can use. It sets out information on each of those tests, but it also provides a lot of information on the process in terms of how you make the CPO, in terms of compensation, in terms of notifying all those third parties. And there's also some really useful guidance in there, which got added in a few years ago, about how an acquirement authority, when they're looking at financial offers, can actually look at other factors as well as just the market value and the other heads of claims that Jack mentioned. You might also look at the cost of not needing to use your CPO powers, the cost of not having a 2-week public inquiry, the cost of actually being able to get on site on time. However, that actually means that you can justify offering a little bit more. And a lot of local authorities that we work with often will offer, say, a time limited offer of an XX amount extra than what they would normally be entitled to, if that means that they don't have to go down the whole CPO process, whereby you're then paying for officer time, often external consultants' time, and obviously inspectors' time and QC time. Next slide, please. And then the other key bit of documentation we just want to refer you to is anyone who is an RICS chartered surveyor will be aware and need to follow this professional statement. So there's a professional statement from the RICS which came out about 3 or 4 years ago. And this actually sets out all the requirements that if you are doing work for compulsory purchase of how you must meet those. So if you are appointing a surveyor to act advising on compensation, there's a number and a list of information that they must be able to show that they can meet those tests. So for example, having the right expertise, having knowledge of case law and statute. And there's also really useful guidance and information, not guidance, is actually parts of it is guidance, part of it is professional statement, but there's actually useful information there on if you are acting as an expert witness and carrying out negotiations, how you must make sure you are charging for your time appropriately. Next slide, please. And finally, before we take questions, again, really just a bit of a signposting for you. As Jack mentioned, there is a DCLG estate regeneration strategy. And in here, there's a lot of best practice in terms of where we are carrying out estate regeneration schemes. And a lot of this focuses around residence charters and rehousing offer. One of the big issues that has come up on a lot of estate regeneration schemes over the last 5 to 10 years is, and I know there's some questions that have come up linked to this, is what about those people who are actually moving them out of their home? So those actual residents, be they leaseholders or tenants, what is the approach for those? And often nowadays it seems to be the main best practice, which is again in this strategy, is we're actually having an offer for residents. So an actual written document saying what the commitments are that the council will make to those residents. And the key things really often are about staying in the local area, not always necessarily the site due to the phasing of the scheme, and also about staying in home ownership. And again, as Jack touched on, there's also an emerging good practice on business charters. So again, where we are redeveloping town centres or business uses, including on estates, what is the minimum requirement in addition to the actual compensation that we might help some of those businesses with? It's not as far ahead yet as a lot of the housing regeneration kind of best practice, but it's kind of an emerging field really of what should we be doing for those businesses. And we'll end it from our side there. So thank you for your time, everybody, for coming in today. And I think, Katie, should we hand back to you to organise some of the questions?
Yeah, brilliant. Thank you all so much. That was great. We've got plenty of questions in the chat, so I'll just go through and pass them over to you now. Is there a general timescale for land assembly as part of the CPO that is required, or is there an advised timescale that should be pursued on average?
Yeah, I think you've asked the $1 million question there, really, and I think the question that we're probably most frequently asked, and the questions around how long you should negotiate before the CPO process starts and etc. is one of the questions that we spend quite a lot of time on. I think that whilst we're very clear indeed that negotiation is the first priority in all of these, the MHVLG guidance that Alison mentioned is actually quite plain in saying that it recognises there are benefits in many instances to running negotiations in the CPO process in parallel. And I think that when for each project you should think about whether that is the case. Sometimes making the in principle decision to use CPO powers and maybe start the land referencing process really focuses people's minds on negotiation. They think it's going to happen. Certainly we talk about schemes where there's been a long run into this and people are just a bit like, well, you keep saying it's going to happen, but it's not, and why should I spend time on it? So I think that we would not really want to end up at a CPO inquiry without a good 9 to 12 months of negotiation in advance of that. But I think that there may be instances where that's not suitable for various reasons. And I think that we're very happy that you might run that in parallel to emphasise to people the importance of this site assembly to the project and to the wider area. And then we overlay that with the CPO process, which has got that sort of timetable, the 18 to 24 months that we talk about. So it's a bit of $1 million question, but there's a balancing act to be done there in terms of those negotiations. Thank you.
Brilliant. So we've got another question, and this had a couple of likes on. So in London, on sites where a residential ballot would be required, would you need a positive residential ballot result before the CPO is made or before the public inquiry?
Again, I think this is something that is a really sort of relevant issue to us, all of us working in London. It seems to me that you are balancing up when the timing of the resident ballot to early enough so that people that you're sure that the scheme's going to go ahead. So the balancing up of the sort of time and cost that you would spend on a project ahead of that certainty, because for those who are not involved, there's a requirement in London, Mayor of London requirement for a ballot to allow an estate regeneration scheme that affects, I think, more than about 50 existing units, I think it is. And so there's a real balance in timing of that. My view would be that you would probably think about your resident ballot being around and about the time of the planning process, because that would give you certainty. You'd have enough design done to be able to show residents what you are planning and how that was going to affect them, together with not having gone through the whole of the planning and CPO process and then being stopped at the far end by a negative resident ballot. So, but it's a real balancing act. Alison, I don't know whether you've from your experience have any sort of more black and white answers on that, really.
I guess just a thing to add, if you remember, we talked about by the time you get to the inquiry, you want to be showing that there are no impediments to delivery, which if you need a ballot, that could be a potential impediment. And also you are wanting to show that you've got funding in place for that scheme. So if you are needing to do that ballot to get your funding from the mayor, which in some cases is one of the reasons for the ballot, again, as Virginia says, you just need to look at that timing as when are you going to have that ballot to the time you get to an inquiry, you can be showing the inspector, right, we've got that funding from the mayor. It really depends if that funding is you really need it, or if it's something that you would like to have is kind of one of those considerations as well. And I suppose the only other point on that as well, I previously worked for a local authority prior to ballots coming in, and there was a similar issue, but one of the big concerns are if you leave it too late to do something like that, you then have a lot of discussion on that ballot at the public inquiry, which is obviously not what you're wanting to have. So whether it's something that you can just have done, ticked off your list and then have got that done, so you're not re-entering discussions on a ballot at a public inquiry into the CPO. So in summary, I think, as Virginia says, there's a lot of different things to consider, and it's kind of weighing up all those various elements.
Brilliant. We've got a couple questions on stalled sites, so I'll just ask them together. So the first is asking if there is a general rule of thumb for how long a site has to be stalled for before a CPO. And then the second is saying, can CPOs be used to deal with stalled developments where developers cannot or will not complete a development?
Okay. I think that, as you might have noticed from our answers, there's very few black and white answers in CPO. A lot of things are subject to X and Y, but my view would be that can you use CPO to deliver stalled sites where the developers cannot or will not? I would say is a fairly strong yes, to be honest. The purpose of these powers is to allow the public sector to be proactive, to intervene and to deliver the benefits of development to and regeneration to the public. So I would say the principle is absolutely yes. And I think going back to the question about how long the site needs to be stalled for, that is one where I think you're looking at probably some individual elements of the site, because there might be sites where the site is stalled for only a short amount of time, but it's absolutely clear from discussion that developer is not going to be moving that forward anytime soon. And there might be other sites where a developer is working, really quite collaboratively with a local authority, and therefore it wouldn't be suitable. So that's an issue there. The key for me on a stalled site would be, as Alison has talked about, that by the time you get to a public inquiry, you could show there are no impediments to delivering the scheme which sits under the CPO. So if a site has stalled because the market doesn't support delivering the housing on there, what is your plan to intervene in that, to support that delivery and to make sure that scheme goes ahead? So it might be more about what is our justification and what are our plans to intervene and get to delivery might be your deciding factor, rather than the time that the individual site is stalled.
Brilliant, thanks. And we've got another question from Eben that's also had a few likes. So this one is, if you have a multiple CPO strategy, would the market value increase as a result of the regeneration associated with the first CPO, influence or increase the compensation properties affected by subsequent CPOs? If that makes sense. If not, we can get
it does. Yeah, it absolutely does. And I think the answer is potentially. So you heard Jack talk about that when we're looking at market value of properties and for acquisition, you would look at a market value ignoring any increase or decrease in value due to your scheme, which sits, which is the purpose of your CPO. So I think that if you were looking at a multi-CPO strategy, you are likely to want to, at the very beginning, think about how you can ensure that your description of the scheme is the whole project. So, for example, the West Hendon 6-phase estate regeneration that we talked about, how can we be very clear that the scheme is the whole phases 1 to 6, and that each CPO is simply facilitating a phase of that, rather than allowing each phase of it to be seen as a separate scheme. And I think the view that we took in consultation with very eminent QCs and legal team is that it'd be a combination of how the planning works as an outline planning for the whole site, potentially might provide evidence that there's a whole scheme. What does the planning policy say? And how can you provide that narrative and story in the statement of reasons for your first CPO, which then sets the stall out for your second and subsequent CPOs to simply be a continuation of delivery of the scheme. And then that gives you a good argument that when you are ignoring the scheme, you are ignoring the benefits of those earlier phases, bringing to the sort of value of later phases. But it is, I'm not sure it's an exact science. It's a matter of building justification and evidence as early as possible, rather than it being exact science, I'm afraid.
Okay, so next question we've got, can you expand on the severance injurious affection assessment of payments?
Yeah, so severance injurious affection, as Jack was saying, is in a situation where part of a property is acquired rather than the whole. And so the examples might be that if you simply bought a garage or a strip of garden from a house, the value of that might be maybe £10,000, but actually the value of that house without a strip of garden, the additional garden, or with a road being closer, might be £50,000 less. So the severance and injurious affection would allow a claim for the £10,000 and the remaining sort of £40,000 of loss of value.
Okay, great, thanks. And then we've got another question here. So have there been any developments on how community displacement might affect the wellbeing test since the Aylesbury estate case?
Oh, you've asked exactly the right people, because both Alison and I have been involved in the Aylesbury estate. I'm going to let Alison start with this because she's been involved for a significant amount of time on this project. So Alison, you start, and there may be something I want to add in at the end.
I guess just as a way of background, I suppose, for people that aren't so aware of the Aylesbury estate. So this is one of Southwark's large housing estate schemes, which 5-6 years ago they sought to use CPO powers for. They had it confirmed on the first CPO, on the first scheme, no problem. Second one, though, unfortunately did not get it confirmed. And the inspector, one of the reasons was there was a huge amount of people that turned up at the inquiry and a lot of concern about people being moved off the estate and not necessarily been able to stay on the estate. So this was basically resident leaseholders on the whole. And I think from there became a lot of concern amongst many people, many local authorities then I guess got quite concerned, because I think some of the questions we've seen in here, the actual test under the legislation is simply about providing financial compensation. It's not about actually providing new homes for those people. But as we've mentioned, best practice has started to be that you normally would try and provide new homes. And I think this is one of the key ways that this has now actually become kind of a mainstream point for most local authorities. As I mentioned, most local authorities now have a residence charter. And a lot of the work that's being done around that is actually not necessarily re-providing those people on the same estate, as it may not work through phasing, but actually looking in the wider area. So let's say, within a couple of mile radius, can you re-provide homes for those people there? And can they potentially come back to the estate once the next bit of the scheme's been delivered? And looking at all sorts of shared equity, shared ownership schemes to get those resident leaseholders back onto the estate. So I think there has been a lot of development, and I would say in our experience so far, there's no local authority now that we work with that wouldn't have some form of housing charter, some form of housing commitment, just to try and stop those kind of issues coming up again, particularly as a lot of those issues often affect people under the Equalities Act. And there's often a lot of older people living on those estates who've been there for many years, often people from various ethnic groups. And so it seems to have become now that it's kind of the standard that you do actually have, as I say, a very clear housing charter and a very clear policy on how you deal with that. Notwithstanding that, it's still not actually in the legislation, but I think it's very unlikely now that you'd get a CPO through without having some really clear kind of rationale and thought process as to how you're dealing with those people who are actually on the estate. And I should emphasise, this is really still very much on residents. It's still not really as much the case for businesses. So the Aylesbury very much focused on households, not actually on the businesses that were potentially needing to be relocated. So hopefully that's clear. I don't know if you want to add anything, Virginia. Virginia gave evidence at one of the later inquiries. I don't know if you want to add anything on it as well.
I think that was a very good explanation, Alison. But I think there's a couple of things I would say is that the exact details of the terms of the offer that is being made to residents, which would enable them to stay within the area and stay in home ownership, are becoming ever more important. And how we explain that to people is ever more important. I think that I probably spent a reasonable amount of time on the stand working through the standard form of lease that would be available if people chose to take up a shared ownership offer on the Aylesbury estate. And as I guess surveyors and people that work in property, we have to be a bit aware that how you explain relatively complex issues to people who are quite upset and worried about what's going on is a tricky thing. So I think there's been a significant increase in the understanding of the value of those that explanation and engagement with people in terms of that. And as Alison said, the equalities impact is the key, and equalities impact, the ongoing assessment of that throughout the whole process is something that I think has been significantly increased over the last sort of 5 to 8 years. The one thing actually that hasn't been assessed, and it comes up occasionally in objections and it comes up occasionally in questions, is that in making a CPO, you often say, oh, and these are going to be the economic, these are going to be the social, and these are going to be the environmental well-being benefits. And quite often they've got figures against them, and they've got, as we say, jobs and, you know, transport improvements, etc. And what is not clear is whether anyone goes back once the scheme is completed and once the, you know, people living there or the new, you know, transport system is in place, whether anyone ever goes back and checks whether any of those benefits have been delivered. Have they been delivered in the kind of quantum and type that we're expecting? So I think that's a question that would be quite interesting if there was a academic researcher that was interested in that. I think that would be an interesting subject.
Brilliant, thanks. And then we've got time for one final question. So I'll go to Alexander's question because it got a number of likes as well. So he has asked, acquiring by negotiation can become difficult when landowners' expectations increase drastically when they hear an LPA is looking to purchase their interests. Any tips for combating this dynamic?
I only wish we did. I think that's a common situation, and people believe that they've got the ability to ramp that up. I think some of the things that Alison was talking about, and I'll hand back to her, about being very transparent and very straightforward up front from the beginning, are helpful in terms of that. But I'm not convinced that we have a magic answer in terms of it. But particularly in instances where developers have been around in the past and offered, say, options for very high values, this is a particular issue for us. But Alison, I don't know whether you've got any other thoughts on that.
Not really. I mean, this is one of the main reasons why CPO powers are there and why we do use them in parallel with negotiations, because, you know, precisely for this reason, people start to have expectations raised, and actually until you actually come along with those CPO powers and you're clear that actually you're assessing value under the compensation code, under the elements that Jack sent out, you know, people start to get more and more expectations. And, you know, as Virginia says, in a lot of our schemes, people sign up to very high options, strike values in those options, which, you know, we don't think would ever get realised in the actual market. So yeah, it is really just about being very clear, I think, with the people that we're negotiating with. I suppose another point to add from a practical point of view is about always trying to encourage them to appoint a surveyor to act on their behalf, so that they are actually getting some genuine surveying advice on what the market value is. It doesn't always work. Often someone won't take the advice from that surveyor, but at least then they have actually got that advice, you know, in writing of what that surveyor thinks that market value is, so they can try and lower their expectations.
Yeah, absolutely. I think we completely support that. And I know a number of local authorities have concerns about recommending anybody to people, and people, of course, have the ability to choose their own. But what we quite often have is an alphabetical list of 4 or 5 surveyors who act for people in similar situations, who we would hand out to people just to give them a starting point. Actually, I understand that MHCLG are updating some claimant guides that were first published in 2001, which I was involved with in the first place, which shows how long I've been doing this, sadly. But they're now, I understand, updating those, and they give people affected some very clear, useful kind of simple language flowcharts. They're going to be published soon. And again, they're very helpful in terms of handing those out. It's sort of an independent bit of advice for people so they can start to understand the situation and start to sort of maybe roll back their ideas. But none of those are magic tricks, but they're the sort of things that start to help us.
Brilliant, thank you. And thank you everyone for your questions today. Huge thank you to Avison Young and the speakers today. It's been such a great session. I hope you all have a great afternoon. Thank you.